Welcome to this unidentified channel. I want to get straight into this video, as I even had to go back and watch my last video to see where we left off. I know it's been a while and I appreciate you for sticking around. So here we go. A lot has happened over the past few weeks in the Daybell case, and so I'm just going to run through some of the highlights and get us all caught up to where we are today. In the last video, we went over the hearing regarding the motion to compel that the defense filed against the state wanting discovery that he hasn't turned over. And we know how that hearing ended, right? Judge Stephen Boyce ordered Rob Wood to hand over any discovery regarding all the names that Mark Means had listed and all the specific things, and he didn't really have to address the last three, which were very broad statements that Mark Means was looking for. After that hearing, I believe the next time we were going to be in court was going to be March 22nd. And then after that hearing, some things were filed and we went back to court on March the 8th. I'm going to go over the few things that were filed, and then we'll talk about what happened on March the 8th. So the first document filed was from Mark Means on March the 1st regarding the motion to transfer trial. He lists Colombo Investigations, doing some survey work. All right, we have some paperwork that was filed from the defense talking about Heather Daybell being a witness in the motion to change venues, also talking about that they didn't hire expert survey takers, and that they also went into that their lay witnesses should not be construed as an expert witness, and they are there just to lay the foundation of why the trial should be moved, have a change of venue. All right, so those filings were done on March the 1st. Rob Wood files his own motion to compel. He wants the information about the witnesses the defense plan on calling to give their testimony on the surveys they took and why we should change the venue. Apparently, the defense is not giving that information to Rob Wood. He filed motion to compel. He wants the information. That hearing was set to take place on March the 8th. So we all watched that hearing. All right, moving back just a little bit, we haven't got quite to March 8th. On March the 2nd, the motion to compel was filed by Rob Wood. Then we have this hearing set for March the 8th to discuss this motion to compel. On March the 6th, Rob Wood filed a brief in support of the state's motion to limine. Now, I didn't see the actual motion on this, but the brief goes through some of the facts about the testimonies between a lay witness and an expert witness, and the different kind of polls you can take and who actually takes the polls and their credentials and things like that. What I found was it is very common for this to take place on things that the court doesn't want to come out to the public. They want it quiet. They don't want it to affect the way a juror feels. For example, if the results of Tammy's autopsy came out and they weren't in favor of natural causes and there was some foul play involved, then that may not come out. They don't want that to come out and taint the juror for the trial that's happening now. That has nothing to do with Tammy Daybell. That's a good example, I feel like. Yeah, anyway, so we have that motion. Early in the morning on March 8th, before the hearing regarding the motion to compel, Mark Means filed a subpoena to have Heather Daybell show up in court on March 22nd at that hearing regarding the change of venue. Apparently, the defense believes that her testimony would be good for their side in having the jury trial moved out of Madison County. Later that day, we actually have a hearing. We all log in and pull it up to watch, and we see them all come on the screen, and pretty much immediately Judge Stephen Boyce says, I need to talk to Mark Means, Rob Wood, and the clerks in a breakout room. He didn't mention John Pryor at the beginning.
Good afternoon, Mr. Pryor, Mr. Means.
Good afternoon, Your Honor.
Good afternoon, Judge.
And Mr. Wood.
Good afternoon.
All right, this is the time we have scheduled on some motions on these cases. Before we start, there's a matter I need to discuss with counsel, Mr. Means and Mr. Wood. I'd like to just have a brief discussion off the record in a breakout room. So, Madam Clerk, if you could arrange for a breakout room, I'd invite Mr. Wood and Mr. Means to join. If you'll hold tight for a minute there, Mr. Pryor will come back on and commence with the hearings this afternoon.
So they attempted to do that. There was some technical difficulty involved in some of that, so it probably took a little longer than expected. And then we see Rob Wood come back on and say that he should be in the room with the judge and Mark Means, with the clerks and Mr. Pryor. So the lady confirms, are you wanting to be in a separate room? And Rob Wood says, no, I think we're supposed to be in the room with the judge and Mark Means.
Eileen, can you hear me?
Yes, Rob.
So the judge would like me, Mr. Pryor, and the court reporter to go into the breakout room.
You,
I don't know.
the court reporter,
And Mr.
Pryor. Okay.
Yes.
In a new room, right?
Well, I think just the one that the judge and Mr. Means are in right now, if that's possible.
Okay. Oh, sure.
So now we have all of them in the room together. And then you see the judge come back on and say it's him and Mr. Pryor on the screen. And you see the judge saying that we should all be in a breakout room together.
All right, I think we're back. We're back on the record here, or we're in the main room, not in the breakout room. What we're trying to accomplish here is a breakout room with the court reporter, me, Mr. Means, and Mr. Pryor, and Mr. Wood.
And so this whole breakout session lasts lengthy, right? About an hour. It lasts about an hour. And they come back on and the judge says, okay, we're here for this hearing. And he states the case's numbers and he goes over who's there and who's represented by who. And goes into, we discuss some matters behind, in a breakout room, not videoed, but the clerk did record it. The judge says he's going to seal the records of that meeting and that they are there for the motion to compel, and that will be vacated.
All right, once everyone's back in the main session here, we are ready to get started. All right, I believe we have everyone now. Clerk, Madam Reporter, are you both ready?
Judge, this is Mary. I'm ready.
Thank you.
Yes, we're on, Judge.
Okay. We'll be on the record here. These are cases CR 222755, State of Idaho versus Chad Guy Daybell, and Fremont County case CR 222838, State versus Lori Vallow. Representing Mr. Daybell's Mr. Pryor. Mr. Means represents Mrs. Vallow. Mr. Wood represents the state in these cases. We have motions scheduled for today, including state's motions in limine, as well as a motion to compel. We also have scheduled a state's motion for remote testimony of a witness. In addition, we've got hearings scheduled on March 22nd relating to defendants' motions to change venue and a currently pending motion to dismiss. We had a discussion outside of the presence of the recording here. It was reported by the court reporter, and I'll note, due to the nature of the discussion, the reporting of that discussion will be sealed, but we did take a record of our discussions. After discussions with both counsel and in consideration of what's been presented to the court does find good cause at this time to vacate the currently scheduled hearings that are set for today, as well as vacating our hearings that are scheduled for March 22nd. The court will set a status conference, which we can use for further scheduling on April 7th at 1:30. And counsel, that will be conducted by Zoom, as today's hearing was also conducted by Zoom pursuant to our Supreme Court's operating order. So that's all we're going to take up on the matter today. Mr. Wood, do you have anything further from the state to discuss this afternoon on the cases?
No, Your Honor.
All right, Mr. Pryor, anything further today?
Nothing further, Your Honor. Thank you.
Thank you. Mr. Means, anything else?
No, Your Honor. Thank you.
All right, thanks. That will conclude our matters for this afternoon then. Thanks for your attendance, everyone. Thanks for the assistance of the Supreme Court for your technical help in Fremont County. With nothing further on the docket, we'll go ahead and be in recess.
Now, as soon as the judge goes into, we're here today for the motion to compel, but that motion will be vacated, John Pryor does this like little twist thing, and his facial expression changes.
Consideration of what's been presented to the court does find good cause at this time to vacate the currently scheduled hearings that are set for today, as well as vacating our hearings that are scheduled for March 22nd.
Right, he's kind of got this smirk on his face. I also noticed there was a time during the hearing that the judge had a slight grin on his face for a brief moment, and that could be because of all the IT problems. I'm not sure. We don't know what happened behind those doors. It was recorded though, so one day we will find out, hopefully. But the smirk on John Pryor's face was weird. Tell me what you think about his facial expression. So the judge goes, okay, we're going to vacate today's hearing. And we're also, with the things that came out today in our discussion, or the things that came up, or the things that were found out, or what presented the evidence, or whatever was said, we're also going to vacate the March 22nd hearing on the change of venue and the motion to dismiss the entire case. And he sets a status hearing for April 7th. Okay, status conference. Where are we on this? We can schedule some more at that date. And here recently, that status conference like here it is, 4/7 status conference. See, I'll put it up too on the screen so you can see it. But right here, it says redacted. Why? Why has it been redacted? What has happened? After this hearing was over, they vacated everything and scheduled a status hearing, and now that status hearing has been redacted, just like the motion to compel shows redacted because it was completely vacated, even though everybody showed up and they did some behind the scenes stuff that we don't know anything about. It shows redacted. Rob Wood sent a letter. I know you've all heard about the letter. I'm just getting you up to date to where we are before this hearing tomorrow. Rob Wood sent the letter to the Madison County, Idaho Board of Commissioners. He talks about bringing Rachel Smith on board as a special prosecutor in this case, and that she's already under contract. Like, it's a done deal. We just need a judge to say it's okay that she can do things by herself, or does she need to be accompanied by someone, is the way I understand it. Like, the contract has been signed, and she is a veteran homicide prosecutor, and she has joined Rob Wood's team. She has 25 years of experience in the complex criminal litigation. She has prosecuted thousands of felony cases in her career, including over 100 homicide and death penalty cases. Over 100 homicide and death penalty cases. So are more charges coming? Are the murder charges coming? I don't know what else it could be. Now, I know when the hearings were first vacated back on March 8th, if you watch Crime Talk, you would have heard Scott Reich talk about, in his experience, it could be only a couple things. Either new charges are coming or they're working on a plea deal. Now, I don't see this ever having a plea deal, but I could be totally wrong. I just don't see that happening when they have expressed already they want to go to trial. They want to go to trial. They want to be convicted by 12 jurors that they are guilty. So I feel like we'll go to trial. Will it be in July? We'll have to wait and see. What do you think? Do you think we're going to go to trial in July? And what is going to happen at tomorrow's hearing? Hopefully, we will find out something after this hearing. I am just very anxious to see what that something will be. We have this Rachel Smith coming on board with Rob Wood. It looks like Rob Wood is getting his ducks in a row to get the conviction. Why John Pryor would have that smirk on his face, I just don't know. Do you know? What do you think? When you saw it, what did you think? What was your reaction to that? Let me know. I need your insight. When you leave your comments below, not only do I read them, but I would imagine other viewers read them also, which gives them new ideas, maybe on things that they didn't see, but they can see through your comments. So make sure you leave your comments below. That's all I have for you today on the Daybell case. Thank you guys for being here with me. I'll do my best to get more videos out quicker. I know the last couple months have been very slow. I am working on it, I promise. Thank you for sticking with me. Thanks again for being here. Let me know where you're watching from if you haven't already. Put it in the comments below. And I will see you next time. If we know anything. We don't know. And if we don't find out anything, it'll be... Okay. What else? You have to do... so you can... And more information can just... Are the murder... Sorry for shaking the camera. Not expertise, not, okay, Mark Means and maybe John Pryor. So we also, okay, the defense is going, maybe somebody's gonna, let's see, before the hearing to yeah, Mark, the defense, okay, very, yeah, I'm running out of video. You know, it was, but the, which, Judge, I can't think of, voice. Where is it? I don't know why I can't keep up with all of this. It's a lot, right? It's a lot to keep up with. Where the hell is it? Oh, right here. Yeah. Okay. Yeah. All right. And I will do my best to get you a video out before next month. Bye.